And in this roundtable, as you can see on the slide, we are going to address the theme of legal mobilization, which, if you listen carefully, you could see in the background of many papers, but as my co-panelists already said, it wasn't addressed explicitly before, and we think, as conference organizers, that it's actually a very important theme. And we have two questions for this roundtable. The first one is, what is the political value of drawing the human rights card? And this can be either in a specific setting or more generally. And the idea behind this is that human rights can perform different functions in different legal settings, such as private law, strategic litigation, constitutional debate, etc. And what is the meaning, and maybe particularly the political meaning, of using human rights as a strategy for action? Does the use of a human rights claim strengthen one's position, or does it have drawbacks too? So that also touches upon the positive and negative side effects. Okay, the second question, which will be the second part of this panel, is on who is being mobilized and for what purposes. So the idea here is that it's not that mobilizing human rights is not just about using legal rights or norms in a legal setting. It's also about engaging other actors. And then the question is, who do you engage? The judiciary, parliaments, social groups, and you can think of businesses, think of a whole range of actors. So who gets mobilized when it comes to human rights, and why are human rights mobilized, used to mobilize these actors, I should say. What we're going to do is give each of our roundtable panelists 3 minutes to introduce their take on this question, on the first question first, and then give the audience the chance to participate in that, and then we hope that that's about halfway, although I'm already running late, and then we can switch to the second question. So without further ado, Leonie Huibers, you are the first to use your 3 minutes.
Okay, well, let's get started. So the first question was, what is the political value of drawing the human rights cards? From my experience with the public interest litigation project, I've been working on a traveller camps policy for those who haven't been here yesterday. And what I noticed was that human rights can really help to put the issue on the agenda. And with the traveller camps, it was that traveller camps and travellers were often seen as a problem, or traveller camps were seen as a nuisance. And through talking about human rights and talking about travellers' rights, we changed the discourse about traveller camps. Next to that, it was also agenda setting, so it was put on the political agenda. Another important part of the public interest litigation project, it is a litigation project, dealing with strategic litigation. And what you do with strategic litigation is sort of a goal-based litigation, meaning that you identify what human rights problems are there, and then think of the ways, the means that you can use to address that human rights problem. And you can do that through litigating at the national courts. And there are some challenges to that, to strategic litigation as well. For example, we started a case about a traveller who had to leave his caravan because of the extinction policy the municipality was implementing. And what you have to look for if you litigate, then on the one hand you have to do your utmost best for the individual, so the traveller. So you want to have a good case, so we provided many civil arguments, civil law arguments as well, besides human rights arguments. And so the human rights arguments were also aimed at this bigger goal of addressing this really fundamental rights problem and trying to get a precedent for other travelers as well. But then you have different interests within the litigation procedure as well. And basically, we won the case at the district court and the court of appeal, but we only won it on civil law arguments, meaning that we didn't have the precedent that we were hoping for. So that was one of the challenges. And I think another drawback of using human rights language, so this is a little bit of a different topic, is one question that I also raised yesterday is whether focusing on the cultural identity of travelers might actually lead to a further stigmatization of these groups, meaning that citizens, Dutch citizens, and the media would regard them as even more different and other than the rest. And one other drawback is, I think, relating to the human rights discourse. I think sometimes one of the things that I was wondering myself when dealing with travelers' rights is whether talking about fundamental rights was really addressing the problems that they were facing. Was this the kind of discourse that they wanted to have or not? And sometimes if you talk about human rights, you can demonize somebody else. So for example, if we would go to the government, as we did, and would say we want these rights to be protected, that they would say, well, we're not even going to talk to you because we would be seen as trying to demonize the government. So those are some drawbacks that I see.
Thank you very much. Our next speaker is Otto Spijkers.
Oh, yeah. So I wanted to focus I'm going to address the same question. So I want to focus my comments on international human rights law because that's what I know most about. So not domestic human rights law or constitutional human rights. So in my view, using international human rights law as a method of lawfare, as an instrument for lawfare, is not particularly effective because the international human rights regime is quite weak. And if you're an international lawyer, you're constantly being reminded of this, especially by bachelor students that are challenging your discipline. So there's no strong compliance mechanism in international human rights law. There is no effective sanctions regime in case of breaches of human rights law. And states have quite some leeway in making claims based on cultural peculiarities or financial difficulties in implementation of international human rights. So as a legal framework, as an instrument for lawfare, it's not particularly effective. But then at the same time, the language of international human rights, so the rights that one has simply as a human being, this language has continued to develop and has in recent times been extremely successful, but as a new moral language that speaks to us at a universal level. So it's been referred to as a global moral vision, a shared moral touchstone, the moral lingua franca of our age, the gold standard of international morality. And those are quotes from various scholars of various disciplines. So also political philosophers have embraced the language of international human rights and have studied it from a philosophical point of view. I find that really interesting because to begin with, it was our invention. It's an international law. It was a subdiscipline of international law, not of philosophy, but now they have come to embrace it also. So as a rhetorical tool or as a moral language, it's been extremely successful. And the second point I want to make is one of the good things about international human rights law, well, the idea is to invoke it against the state. They have the obligations and the individual has the rights. So isn't it wonderful that it's basically the states themselves that have made these promises in the treaties that they ratified? So basically, when you invoke human rights against state, all you do is remind the state of its own promises. You promised once not to torture me, and look what you've done. You have to keep your promise. That's my comment.
Okay. Thank you very much. Our next speaker is Lisbeth Enneking.
Thank you very much. I spoke about this already a little bit in my presentation, and I just for this question I'd like to focus on whether it can strengthen positions or have drawbacks within the legal arena, and then the second question I'll go beyond the legal arena. And I think from my presentation, it is clear that sometimes it can be legal pragmatism to base your claim either on human rights or not on human rights on purpose, depending on the rules that will be in place. examples for reasons why you would, for instance, base your claim, frame your claim as a human rights claim, is of course the ATS example where you already have sort of a movement, you have precedent. It's in a country where access to the courts is easy financially, evidence-wise. So that would be definitely a reason. If you wanted to pursue a claim on the basis of ATS, you would have to frame it as a human rights claim. Another example may be prescription procedures may be more lenient in human rights cases. There may be special procedures with procedural regimes that are more beneficial, that make it more likely that you can successfully bring a claim than when you don't frame it as a human rights related claim. One of the things that was, for instance, interesting also in the ATS procedures was that it had the added benefit of, because they were appealing to international human rights standards, it also meant that the question of which law applies, it did come back in those procedures in a different way, because then there was a conflict between whether they should apply federal law or international standards at some point. But to appeal to an international human rights standard does take away the whole problem of should we look at host country standards or home country standards, and the associated point of perhaps whether it's neo-imperialist to come up with this case in which you apply home country standards to something that actually took place in a host country. So especially in the ATS context, the appeal to international human rights standards took away some of those problems. Also, I think it can lead to to some judicial activism. Courts that may perhaps be moved by these types of arguments that obviously have a certain moral weight, and this is also something that has been mentioned by courts in ATS-based cases, where they said, there was an alternative. They were talking about the possibility to file, instead of this ATS-based claim, a tort-based claim, and then one of the judges said, well, obviously that's not a real alternative to file some sort of garden variety tort-based claim that everyone can file if someone kicks a ball through your window. This is a different category of cases, and so they really recognize that. So that is obviously something to do with the moral weight, and also moving the courts dealing with it to think about these cases in different ways. Having said that, I also think that we should recognize that, especially in private law procedures, so tort law procedures, is basically about a balancing of interests. So there, playing the human rights card typically does not necessarily enhance your position. It's interests on both sides. Both sides can frame their interests as human rights interests. You can have a right to property or something, so then it becomes a weighing of rights that are not, where one right does not necessarily trump the other. So especially in a private law context, more generally, does not always help. And then fourth point was also mentioned here, is a potential for conflict between the people behind the procedure. So basically from a lawyer's perspective, may be very good, it may be better not to frame a case as a human rights case, but from the victim's perspective, they may want it to be framed as a human rights case, or the other way around, because always here you also have the problem of, we all want to create a precedent, because that's really important in view of future cases, in view of public impact, but maybe the victims just want money as soon as they can and don't want any drawn-out procedure. So that's something that I think also in this context is relevant. That potential field of tension between the different interests involved, even on one side of the procedure.
Thank you. Thanks. Thank you. And Jackie Duber.
Thank you. So I'd just like to talk about a particular model of legal mobilization and kind of start with a second question, and not so much framed as who is being mobilized, because actually I definitely think lawyers should not be involved in that process whatsoever, and that lawyers should only get to that process once people are mobilized and want to invoke the law. So to speak briefly about a model that myself and colleagues adopted in Johannesburg, and this is definitely not about the international or even the domestic, but about the local. And it's to invoke a quote by Rick Abel, saying that law, like war, is politics by other means. And we took that and we decided that what other interest groups, particularly corporations and governments, have at their disposal is embedded lawyers, and they become repeat players in the legal game. And what if poor communities, mobilized communities mobilizing for social justice, had access to those kind of lawyers. And so we set up a legal organization that was about socioeconomic rights, which combined litigation, research, and advocacy. And we sat there. We didn't go out. We didn't go and look for anybody, but organizations and communities came to us. We were very clear that we were only servicing local communities. We were going to build long-term relationships with them. This wasn't about one-shot litigation. It was about moving the frontiers of justice forward in whatever way communities thought was the right way to do it. And we would never second guess what that was. If they wanted to come to us with to use litigation, we would try to do that. If not, we wouldn't. And I think that is a very powerful and positive model. And what it also does is make you realize that the law is just a means. It is not an end. And what you always would have to be doing, both I think what you would be having to talk through with communities and with organizations is, well, does it make sense in this? Yes, okay, so you say you want to litigate. Does it make sense in this context? Let's talk about the other options. And so I think, you know, in one's critique and in one's reflection about the role of law and the use of law, it's always important to look at what other options there are. I always say to people, I think it's interesting how little reflection there is on politics as quite, in most contexts, not really a very useful means for most marginalized and excluded groups. And in my experience, actually, the law and litigation has been more useful. And I think it has a range of uses which resonate. I think it's politically, I think it, because of this agenda setting role, because in fact it creates a platform, an arena, where people who are on the margins, where their struggles are not normally seen in the mainstream, whether it's in the media, whether it's literally in the courtroom, etc. I think it has a function of providing voice and of inclusion, which other forms of struggle sometimes don't have. I think it has the effect of providing a lot of information, of strengthening organizations, of a lot of symbolic power, and so I think it has all of that potential. But I also think one must be very realistic about the limits, as we've all said, and so I think it is both at the same time has more potential and is more limited than is often put out there. And I think that it's what is very important to acknowledge is that it is not in and of itself ever a way to, on its own, respond to structural problems and structural inequality. But I think that it can serve that purpose very much. And just a very practical example of that is how when you have used legal mobilization against, for example, evictions, what you have secured is not only that your clients in the community are not evicted, but that they can continue to organize politically where they are for whatever means. And so I think that, and if that means is about overthrowing the regime, etc., you know, that is a very instrumental role in that struggle. So, yeah, that's where I'd end.
Great. Can I ask someone to take the mic to the public? Because I'm not surprised somehow, Tani, that you're the one taking the floor first. Could you, people just raise hands if you... Yeah. You do need it. Yeah, you do need it. Okay. No, I think we're okay. Yeah, we're okay.
I wanted to ask about, and I think probably Jackie and Otto might be able to answer also, when it comes to the political of legal mobilization and problematizing the implications of legal strategy and the implications of lawyers and lawyering on the future of governance within a country, right? And kind of looking at separation of powers and the role of the courts within the governance structure. So I know it sounds a bit abstract, but in terms of the violations approach, when it comes to certain rights that need to be claimed through the courts, and Jackie, I mean, with series cases, I think the reason, for me at least, why it's been really successful is that those cases that used to be resisted by the government have now become part of governance. the outcomes have been incorporated into housing policy. So it's very rare now that you will find someone at local government level saying, we don't provide alternative accommodation. They've accepted Blue Moonlight to a large extent in their policies. At the same time, though, you have cases where, you know, you take a matter to court and a minister is named and shamed in the court, but the court cannot get rid of the minister for ineffective governance. So this nature of how we use human rights law and what kind of strategy we use and how that then impacts on governance going forward and resources for realization of rights, I do think we need to problematize the violations approach a bit more and think more about when we invoke the law as a form of accountability versus the law as a means of politics. And I think sometimes that becomes very messy, and lawyers, when things become unintended consequences, lawyers walk away, and it just becomes the government's fault for not being able to deliver on rights. So I'd like to ask your thoughts about legal approaches and strategy and when we take accountability for the way in which we've invoked the law. Thanks.
Okay, thanks. Great question. Someone wants to react? Yeah.
So I'm not sure I understand why you would see a separation between accountability and politics.
So because I think the violations approach is a naming and shaming game rather than a systemic change.
Okay, but I think accountability, when you hold an office bearer accountable to a standard, I see that as a political process. And so I think you can achieve both, politics and accountability. But perhaps I'm not quite getting your question.
So my main challenge that I'm having with the human rights space at the moment is that the overlap between protecting human rights, and specifically in the realm of socioeconomic rights, and how that then interfaces with governance.
Oh, yeah. No, I mean...
So when we're dealing, lawyers don't deal with resource issues, but rights are directly linked to resources. So we go for a case based on a violation, and we hold the state accountable for the violation, but the violation itself is not being translated into policy.
Okay.
So there's no systemic...
I've got you, but in fact, I think in South Africa it's the opposite, precisely because we haven't pursued a minimum core content approach, and in fact no content to any socioeconomic rights except very recently in Dladla. Effectively, we have a policy and systemic approach, for better or for worse. And some people would say that the reasonableness approach, in fact, because of that, is the right way to go, because it's 100% about policy and about systemic policy. So indeed, you don't pursue a violations approach in socioeconomic rights, really. You are, in fact, looking at, was the policy reasonable? And the remedy is all about accountability and politics and political choices. So that's why I think it's actually very interesting to work in socioeconomic rights in South Africa, because it is entirely political.
Yes?
I know the question wasn't addressed to me, but I think maybe I have a nice reply to it, because for me, strategic litigation isn't just about litigation at courts. I think it's identifying a problem and seeing how to address it. And you don't address a problem if you only have a violation by the court. You need to see that it gets implemented. You need to monitor when it gets implemented, that basically it's implemented at every level. Until you reach that point, you haven't reached that goal. So I think the policy translation is very important, and that's basically what we're now trying to do in this specific area that I'm dealing with, is changing travelers' rights into a policy document, making sure that their rights are protected. And then after that, you still need to make sure that it's implemented at the municipal level and by housing corporations or any other person dealing with their rights.
That's very clear. Is there another question at this point? Yes, Jeff. Jeff, opted out of being a moderator, and we now all understand why.
See, now we understand why I'm sitting over here.
Caught out.
So I'm interested in this conceptual distinction between lawfare and legal mobilization, which Otto and Jackie seem to use synchronistically. And that's interesting to me, because I do think that it's important actually to have this conceptual distinction. So I guess my question is, do you use these terms by accident, or is it intentional? And why? Because do you feel that the conceptual distinction, well, to the two of you, because do you feel that it's important to have this conceptual distinction, or is it irrelevant? And should we just sort of see...
But
it gets back to that, actually, but yeah.
And as a moderator, I would say, I see Otto, who uses lawfare as a very broad concept. And actually, you didn't use the term, did you?
Legal mobilization.
Legal mobilization. As is there a difference to these two terms, or would you see them as being the same thing? And if you see them as being the same thing, I'll give the mic back to Jeff afterwards. You have a microphone.
Yeah, so I'm more familiar with the term lawfare, but that I see it indeed as the more broader term, as using the law as an instrument in getting what you want. If you're involved in a dispute, you use, instead of arms, you use the law as a weapon of choice. And then mobilization, I was thinking more of involving other entities, like the judiciary, or so to mobilize some other entity, and you use it to get what you want. And then, of course, legal mobilization is using legal institutions to your advantage. But maybe I'm interpretation is not entirely.
So to summarize, you would say lawfare is about using the law as a weapon of choice, and legal mobilization is using particular legal institutions or actors or paths in which to use that weapon. So that would be one distinction. And Jackie, would you make the same distinction?
I think that I would see legal mobilization as the invocation of rights or the law as to frame your claim. And I would see, I think I would probably see lawfare in the same way as Otto. And I think it's interesting in that respect, to again go back to Rick Abel's comment that the law, like war, is politics by other means. So there you have lawfare just right there.
Thanks.
I see Lisbeth frowning.
What do you think?
Yeah. Because I think, Jeff, that you have a different conception than our panelists.
I do, but I'm going to leave it for the time being, considering my role.
Maybe my conception of the thing is more in line with, but I'm not 100% sure, because for me, legal mobilization is about, especially in the private law field, where you bring a claim not just with the core aim of getting your damages paid, but to get to a further aim of some sort of socio-political aim. So it's for that for me is legal mobilization. So bringing a claim or bringing a case with an aim that goes beyond what happens in the legal arena and the outcome that you're actually asking. But then lawfare to me, but I'm not 100% sure, would be actually legal mobilization sort of gone wrong, where the other side decides that they can do the same, and then sort of you end up in this battle where both sides also, with a view to pursuing these more public aims, or these aims that actually go beyond the legal procedure, start fighting that fight before courts. And obviously in my field, the Chevron case is like the core example of what I would call lawfare, where so it started out with some sort of public interest litigation, like claim against Chevron because of environmental pollution in Ecuador, and it ended up with Chevron, on the other hand, also pulling out all stops and suing everyone on the other side of the dispute in every court imaginable in order to sort of basically, get them to end their claims or whatever the aim was. And for me, that would be lawfare.
Well, I think that I don't even need to give back the mic to Jeff because he's smiling. So, any other questions? Yes, Alessandra, I saw. And was there someone here as well? No, I think Alessandra.
Okay, now so I wanted to go back to the point of Otto, where it's like this creation of a moral language of human rights. So maybe a background, I'm not a human rights lawyer, but I'm an international economic lawyer. And there, what I do see is that it has a mobilizing power, the human rights, as a counter discourse to how international economic law can be used to cabin out all other interests from the discourse. So used in a very loose way, but and I'll just give an example. For instance, there was a case recently in international investment arbitration in which a counterclaim has been used, arguing for using the right to water. So according to human rights lawyer, the arbitrator that really stretched the law to accept this counterclaim. But I find this very fascinating, how you can use a right system as a discourse that can alter another legal system which used to be very much closed off vis-a-vis other legal systems. So, I don't know, it's a comment, question, or conversation.
Do you want to react? Yeah.
We refer to that as the humanization of international law. So this was very much in fashion a few years ago, and people would write books about how international human rights law has affected international economic law, international environmental law, all other sub-disciplines of international law. And I don't think that kind of research, conceptual research, is being done now, but it was very much in fashion a few years ago.
Okay.
So to just show how deep the impact of international human rights law really is on international law. And,
I think that in some of our answers we already touched upon aspects of the second question, so I think it's time to move to that. And actually I want to give Jackie the floor for that first. We'll go in reverse order. You already covered it. Okay, well then, you see, yeah, okay. Then Lisbeth, you're next.
More time for me, right? Yeah. So the comments that I had to the first question, I tried to limit a little bit to impact within the legal arena, and then I think like what we already talked about, I think many of these cases, also the case that I'm talking about, also the private law cases, are actually also about getting effect outside of the legal arena. So who do we want to impact them with these cases, or we, the people bringing them? I think first of all courts. Obviously these cases are about getting a court to set or operationalize standards in a field where the legislator has for some reason is not able to set clear and binding standards. So I think it's about courts, about mobilization of courts. I also think beyond that it's also about others that are maybe mobilized by these cases, or for instance political actors. It's very difficult not to take up or not to like these types of cases, especially if they're framed as human rights cases. Having said that, I also think that's not necessarily true, that politics will always take up a case because it's framed as a human rights case, because what we, for instance, see, the example in the Kiobel case, was where we saw the Dutch government, the British government, the German government all writing amicus briefs to the US Supreme Court telling them, you know, drop this case, drop this case. Well, this was the seminal case of you know, the seminal business human rights case. And they all argued in favor of basically the corporate defendant. So there, it actually, they took the other position. So they didn't apparently feel compelled to go for the human rights position, which in their sort of domestic, or hey, if you hear the Dutch government speaking about itself, they think they're the advocate of human rights. But when it comes to, you know, when it really comes to the deal and it's about human rights versus Shell, then actually they take the other position. But anyway, but it can be an attempt to mobilize politics. Another example of cynicism is in politics is the legislative proposal on a duty of care in the context of child labor that is currently before the Dutch Senate. From abroad, people looking at this from abroad think, oh, this is a really interesting development. The Dutch are really front runners in this respect. But actually, that's really not the case, because this proposal, where you could also say what's not to like about about. I mean, but the political parties, for their reasons, which is mostly because the political spectrum is quite a lot to the right at this moment, have found many reasons not to like this proposal. So they're now basically going to shoot off this proposal on all sorts of procedural grounds and saying, oh, this concept of due diligence, well, we don't really know what it means, so no, we can't come up with it because it's so much legal uncertainty. So they really do find a way. You would say they cannot sort of drop a proposal about child labor, right? I mean, we're all agree that child labor is something really we want to ban, but they do find reasons, that apparently they don't have any problems with finding all sorts of procedural reasons not to like this proposal. Then other groups you could mobilize with these, you can attempt to mobilize with these procedures, would be consumers, basically the general public. Although I must say also that there are quite a lot of studies, I think, that show that it's actually notoriously hard to mobilize consumers, that they're really really hard to mobilize in this context of CSR, and that to get them to not buy their Primark T-shirts is really difficult. Then obviously, and this is interesting, also a group that can be mobilized are potential employees of the company. And this is, we had an article in the Financial Dagblad 2 weeks ago about sort of bright young scholars not wanting to work for the dirty shell. So obviously, I mean, and this will also have an effect on the company, because for the company, I mean, they do want these bright young scholars. So that's a group that can be mobilized. Then obviously mobilizing the corporations themselves, getting them to, for whatever reason, because they internalize whatever is happening and really feel sorry about it, or because as a strategic reason to protect their reputation, they may decide after a lawsuit to change the way they do business. And then lastly, but definitely not least, investors. Studies show that the Kiobel decision by the US Supreme Court had an impact on share prices of the companies of the companies that were not based in the US, because of that judgment, those companies could not be targeted anymore by ATS-based cases, and that actually had the result of the share prices of those companies going up. So we see that investors are also watching this type of litigation, and then the next question is, why do these investors react? Not necessarily according to economic models because they themselves have a moral, but because they try to estimate what other actors are going to do as a result of this judgment. And apparently, so in the Kiobel case, they estimated that these ATS-based cases were a threat to the reputation of companies that was relevant because of have potential employees, because of consumers. We don't know what they were thinking. So I think there are lots of groups that can be mobilized. Sometimes the prospects for doing so are larger than with respect to other groups, but there is a lot of potential there.
they want to change things. They see that there's a human rights problem. Only they don't have the means to convince the political leaders, or they can't convince the minister they're working for. So basically what they said to us, we need your help in doing this. So all those other actors that I just mentioned before, CERT, AP, NIR, National Ombudsman, judicial proceedings, media attention, the visit of the king, then it becomes clear to the minister that they need to do something. I think so that's an act that we shouldn't forget mobilizing the rights.
Well, thank you very much. Jackie, have you reconsidered? Do you want to add something, or you're sticking to it? Okay. Can I give somebody the floor on these issues of who gets mobilized and for why? Because I have a question actually. Alessandra, yeah, and then I have a very short question myself, which I think is the most fundamental one. But no. It's just
to be this question of court giving a voice and a democracy having lack of full representation, whether I mean, it is in itself legitimate to have some politics in the law as such, also because the law has a lot of ambiguous concepts. So
okay, good. So yeah, I think that's an important point. The politics within law. Does anyone want to react to that? Yes, please.
Yeah, in my view, and obviously one has to understand the counter-majoritarian argument, and as Otto says, of course, the executive and the legislature is not going to like it when nobody likes it, when a judge says what you've done isn't right. I think it's legitimate. I think that democracy is about contestation of power, and it's about checks and balances, and I think the judiciary is part of that. I don't have a difficulty with the idea of judges interpreting the law to the benefit of the people. And I think that it's particularly interesting for me, obviously, as a South African. The South African scenario is interesting because what you get in socioeconomic rights cases is you get the applicant raising an issue about social justice and the government blocking it. And then judges ruling in favor of the applicants. And I just don't think that you can say that that's anti-transformative. Now, you can say it's not transformative enough, and I've often said that. Do I think that it's a separation of powers issue? Well, I think separation of powers is not nuclear science. It's a negotiated line, and I personally think that our courts in South Africa, speaking only about that, haven't even got close to it. They've been quite respectful, particularly in the beginning years, where I think it was right to confer a level of, what's the word? Thank you, deference. It's getting to that stage. Deference to a democratically elected government. But I think at this point, I think they're doing the right thing.
I just want to refer you to the Urgenda judgment, because the court was very aware of this problem. And one quote that I really like from the judgment is the court said, in the Netherlands, we do not have a system of full separation of powers. Instead, we have a balance of powers. And I thought that was brilliant. So there is no separation of powers in the Netherlands. We have a balance of powers. It's very different. And of course, the district court did not make the argument, we don't make law, we only apply the law, because that's ridiculous. Everybody knows that when you apply law, you add something to it. So I was also very grateful that the district court was not making this, this argument that is so obviously false. But okay, no separation, balance.
And by the way, they did say that, you know, what they were doing was the legal stuff, and if it was also politics, they didn't care. Well, paraphrasing a little bit, which was kind of fun. That's. Is there anyone else wants to add a comment here? Then can I then get can I get to my fundamental question? Because I think yeah. Well, the thing is, it's actually in the phrasing of the question, who is being mobilized? And actually the first time around, I phrased it as, who is mobilizing whom? And in a way, it's better, but I thought if we do that, then they'll all come up with lists of 5, you know, types of people on the one side and 5 on the other, and get very confusing. So I reduced it. But what I want to talk about is the people who are, you know, you call them the applicants at some points, who are, and you, Jackie actually said when you set up this office, you waited for people to come to you, right? I don't like the idea of being mobilized. No, well, so the idea of the question is, and that's very, I think for me is very interesting, is that there are people who have a problem, and they mobilize the courts, the media, the civil servants, what have you. Well, in a lot of the examples, it's actually the other way around, and that's what I think the fundamental underlying question of legal mobilization. Aren't you sort of instrumentalizing the people whose fundamental interests are at stake? And I would really like to hear your views about that, actually. And I'm actually looking at Leonie very much.
Yeah. Okay. Yes. Thank you for this question. So I think this addresses the point that I started with interest groups. They are at the start and they are at the end of things, and in between. I mean, they're like all the time. It involves interest groups and the applicants. So I really like the idea that Jackie said that, well, I want the applicants to come to us because I don't want to start something with which they are not dealing with yet, or they don't want to involve, they don't want to start a legal proceeding. And I think, yes, I understand. I find it a difficult question because in a way I don't think it's maybe more a chicken and the egg thing, because it is difficult for individuals to find the right people to carry out their litigations for them if they haven't heard of it before. So in a way it moves around, and I think what we did with PILP in the beginning was to organize a brainstorm meeting in which we included lawyers from big law firms. We invited many travelers, Roma, Sinti, and experts, academics, and we just talked about, did they have a problem? And well, it was quite clear that they already had a problem, so I don't think that that issue was already addressed. But then consequently, the question was, what is the real problem that needs to be addressed now? What can we do for you? So I think, yeah, for us it went around and we kept coming back to the interest groups, and the interest groups kept on contacting us with new problems and new issues that they were facing. So, yeah, in a sense, I think it's a chicken and the egg thing for me.
Yeah, thanks. Lisbeth, you have something more to say about that?
We both already spoke about the potential conflict of interest between what the actual victim wants and what the interest group thinks is in the best interest of, from a legal pragmatic point of view, or perhaps from a principle point of view, can go either way. So there is definitely a field of tension there, and also what you hear also is in my field is now criticism also that human rights litigation is becoming an economic model for some of the law firms. So saying that the law firms actually in some countries you can get quite a large amount of damages, and then they take off a percentage of that. So there has been that's where sort of human rights lawyering becomes sort of something more and something that to be made a profit of, and so there is obviously a fine line there as well. What I also wanted to point out is that for the NGOs, basically or the human rights lawyers behind this, there is a fine line with respect to the clients that are behind the claim, but also with respect to who are you targeting in your procedure, because research shows that it's actually usually, there's this really nice article that says good firms, good targets, which means that at least in my field where firms are targeted, it's not always, or in many cases, not the bad guys necessarily that get targeted, but actually the ones that are trying to do good and are quite transparent about what they're doing, and then bam, they get sort of slapped with a lawsuit. So I think also there you can raise some questions about strategies, and also about the important role that civil society actors play there in maybe not always going the easiest route, but trying to really keep in mind why they are doing what they're doing, and trying to not get the easiest target, but perhaps the most deserving target.
A very important question that my father and I were discussing the other day is, can we regard Amal Clooney as a human rights lawyer? I think I'll leave it at that.
Okay. Are there further questions about this? And I hold two mics. That's no. In that case, given the time, I propose that we end this panel. I hope it gave you food for thought, and I want to thank our panelists. And we'll turn straight away to our final program item, which is the keynote lecture by Jonathan Claren, and Jeff will introduce him. Okay. Then it gets scary, Jeff, when you start to ask the same question. That's the best mic.
Wow, we have a few of us left here. And I think a very committed group of you who spent the last day and a half with us discussing what have become our hobby horses in INFAR. We've really appreciated you being part of this project and thinking with us as INFAR goes into its next phase. Oh, I see now Elaine having joined us. Well, you are just in time to hear the final part of our conference here, which is by somebody who I've known for quite some time. We worked together when I was in South Africa in the first time in the early to mid-90s. You were then a junior lecturer. I was then a young lawyer, and we were working together on issues around refugees and asylum seekers. In the intervening years, I'm not going to say how many, we have since become both parents to children. No, not together, no. No, that's important clarification, yes. We both have our own families, and we've indeed done a lot of academic work together. Jonathan Claren is now a professor of law at the University of Witwatersrand. He's held that function for quite some years now. In the intervening years, he's also been dean, head of school of the School of Law at the University of Witwatersrand. And he's currently, I think, primarily attached to the WISER, which is the WITS Institute for Social and Economic Research. Of course, also part of WITS University in Johannesburg. Jonathan has been very active in the Law and Society Association, an organization which brings Sana, Sanella, Jackie, Jonathan, and I, Elaine, indeed, as well, regularly to meetings of the LSA. Nathaniel, of course, has also been coming for the last few years. It's a place where, which has generated a lot of discussion also around these issues on legal mobilization. Indeed, I think there's even a CRN on legal mobilization, the Collaborative Research Network. So Jonathan is indeed the perfect person to, I think, give a keynote address, and I'm sure he will be speaking to a number of the issues which were discussed in the last day and a half. So Jonathan Claren, please. Yeah.
Okay, thank you very much, Jeff. I agree with almost everything you said. We did co-edit a book together, and that's almost like having two. Yeah, that's right. It's actually, you don't forget your children, so maybe it's not exactly like a child. But yeah, I really appreciate that partnership, which I think is ongoing. And I think that's an opportunity to say thanks very much for not only you, but the rest of the INFAR team that's organized this workshop. We're at ISS, but it's ISS, I know, and the Erasmus School of Law together in doing this, and I think it's really, it's been great. And I think that you've made us feel, at least from the outside, as insiders so far here in the Netherlands, and that's an important thing. I'll do some reflecting on the inside and outside theme. I took this opportunity as exactly that, an opportunity to do some reflections on the theme, so I'll do that. I guess I'd also like to say, just before getting into things, that in addition to thanks to the organizers, there's been participation. I see a few new faces in the room, but many of us have been here for a day and a half already, and there's really so much there. I actually will try to make some points of connection or some points of comment in the course of this talk, but it's really too rich to be able to do that throughout. So I think it kind of has to be, I feel fortunate to have the chance to try and pull some of it together, but it's really too much to be able to really consolidate all of it. So with those 2 points, the third point I want to make as a prefatory one is a little bit lighthearted, which is please be on the lookout for 2 particular photos or slides, because 2 of them will reference directly to previous presentations. So it's kind of a spot the whatever it is in the presentation. So please put up your hand when you see something in the photographs that make you think, oh, either I've seen that before or I haven't seen that before or something like that. Okay, I hope that's enough to keep people awake. Yeah, sure, Snelly, I'll buy you a drink. Or whoever gets that. Okay, so I go down, that's right. Or sorry, Jeff. Okay. All right. So I thought about this. Ooh, it's pretty small up there. I thought about this in 3 movements. Yeah, it's pretty small. So I'm sorry, I'm going to have to do a little bit of turning back around, but I think we'll all be all right with that. And then just in terms of the materials here, the organizers do have a paper that I've put in, which I'm sure can be distributed. And then this presentation, in the first movement of these 3, does actually speak to and draw from that paper, but in the second and the third moves beyond that. So I think that'll also be available to workshop participants. So in the first one, I'm speaking on new African perspectives on corporate, and I put criminal into parentheses, accountability. That was in the title in the beginning, and I think it is still there, but it's not only about corporate criminal accountability. I want to speak about a case called the ins and outs of, well, the case is called Kulimani, so I want to speak about its ins and outs. And then Kyobo. We've heard quite a bit of discussion already on Kyobo, and I think part of what I'm doing is to be looking at this earlier case of Kulimani from the perspective of Kyobo. and looking at it in, in perspective. What does that case look like in the aftermath of Kyoto, and new developments there. Second movement is to, in some part, really move away from the kind of talk we've had to this point, and to go into sociology of law. I want to speak about law's endogeneity, and then in the third one to actually move into linkages to the workshop topics. So that's the outline of where we go. Okay, so Kulamani. It's this paper that is actually here in the workshop started out 8 years ago when Kulamani was a going concern at that point. And it was an ATS, an Aliens Tort Claims Act, some ATS, ATCA lawsuit. I want to go through some of the sort of details of it here. Starts in 2002 and ends in 2016, actually. So it's a 14-year piece of litigation, which is actually to be part of the theme. A group of South Africans, partially represented by the Kulamani Support Group, sues banks and corporations in U.S. federal court that did business in South Africa during apartheid. There are several sets of lawyers for these plaintiffs, including multiple sets from both South Africa and the U.S. We were just speaking about law firms that have economic models within their firm of taking on this kind of business, and that definitely was a feature in this Kulamani case. So in part it's styled as a class action. The plaintiffs are victims of human rights abuses, extrajudicial killings, torture and rape, allege that the defendants' activities, the banks and the corporations in South Africa during the apartheid era made them complicit in the commission of those abuses. And the view of the government's quite interesting, the politics here. Initially, the South African government was opposed to this suit under Mbeki administration, and actually filing views and publicly stating that their opposition to the case being heard in this New York courtroom. Here and in the next slide, I'm trying to make the point about how complex it was, but I am just moving over saying much lower court wrangling ensued. From 2004 to 2008, many motions, many courts were involved. I'm actually not aware of, but perhaps there is a kind of complete summing up of this litigation, and I think that would actually be an interesting project that should be looked at. Here's some photographs that sort of try to give you a sense of the litigation. The Kulamani Support Group, we'll come into the story a little bit later, but I think that's their logo, important here. It's a support group that effectively began out of persons who were claiming as victims in front of the TRC. Here's the reparations. This is at the time of the World Cup in South Africa, 2010. So you see the sort of blood dripping out of the soccer ball. Not sure about the soccer ball manufacturers. I'm pretty sure it was actually manufactured in South Africa, not in Pakistan or wherever we were speaking about earlier. So those are some of the defendants that are up there. And then this really, this other photo here is an older photo from apartheid days, and I think it really, I put it up there because it shows, one of the names for this case is actually the apartheid reparations suit, so it really shows that this is a lawsuit, but it's a political instrument, a political platform that for many groups, for many governments, is actually linking back to apartheid, to the end of apartheid. Well, to what is needing to be done in order to, as ironically stated, to bury apartheid. Was apartheid buried when the transition actually occurred? Okay, so the lawsuit continues. There was the federal district court gave a ruling to actually narrow the claims, but allowed the case to continue against Daimler, against these quite serious defendants, right? Ford, General Motors, IBM, Rheinmetall Group. And then there was an interesting shift in the support for the lawsuit occurring when there was a shift in presidential administrations in South Africa, moving from President Mbeki to Jacob Zuma. So this is at that time, and it meant that the American courts were actually now having support from the government for this apartheid reparations suit. There was a small settlement that was reached with General Motors in 2012, and that appears to have occurred mostly because you can think of it significant in a couple of ways, but it appears to have occurred because General Motors at that point was in bankruptcy. And it was actually not really the management of General Motors that was indeed reaching this settlement. It was the persons who were in charge of the bankruptcy settlement, and they felt that this was actually the right thing to do. The money was pretty small, 1.5, I think it's 1.5 million US dollars. So, I mean, even if we compare it to the Kiobel case, the Ken Sarawira settlement on the murder was, I guess, basically 10 times that. So that's interesting to calibrate on. Okay, but on we keep going with the procedural history here. So in August 2013, the Second Circuit remands and recommends dismissing the case, citing the limitation on extraterritorial application of the ATCA in Kiobel. At that point, the district judge lets 2 judges go, but initially declined to dismiss the claims against IBM and Ford, allowing for an amendment of the complaint. And I actually remember when one of the teams of lawyers, and it's not mentioned up here, but one of the teams of lawyers was actually from the Harvard Law Human Rights Clinic, who were supporting some of the claimants and working with the other lawyers. And I remember when they came through South Africa, some of us here probably were also in touch with them when they were trying to gather more information in order to satisfy the court's standard of touch and concern, in order to demonstrate the kind of personal jurisdiction, in order to keep the claim going. So there was sort of hope in that sense, but then the case was actually dismissed, and that was upheld in the circuit court, and then finally 2016 in the US Supreme Court. So there's much telescoping here, but effectively, after 14 years, the case is dismissed on the Kiobel rationale, that there is not a sufficiently close connection between the defendants and the forum where the case is actually being heard. Okay, so I wanted to try and reflect on some of that case from some of the themes of human rights inside and outside. So one was to look at inside and outside the nation state, the firm, and the law. So just in terms of the nation state, and I think it's come up implicitly already in our conversations here, but it's worth reflecting on the idea that the case that is talked about as apartheid reparations in South Africa is actually being heard way in the United States. Don't look too closely at that photo, because if you do, you find out it's actually about the migration of songbirds from Georgia to KZN, but it was the closest I could find to a map that actually went between New York and South Africa as a whole. But there was, quite a bit there about, it's worth reflecting upon that, and I think it also plays into the politics of the South African government going back and forth about whether or not it was actually happy about being part of or supporting a lawsuit against these corporations for apartheid reparations, right? Because in many ways what the South African government wishes to do is to just draw a line, negotiate with corporations around investment going forward, and indeed move forward. So I think it really problematizes, also as an example of transnational litigation, it problematizes the nation state. This was a real political event that was actually happening. I think we've heard, well, we haven't heard so much about, actually we have heard a little bit about how ATS itself is problematized within the United States, and indeed throughout the world, but clearly it had an effect in South Africa as well. And then the firm, right? That's forward over there. It says territory to South Africa in that photo. I think, as I understand it, territory is the name of a new model of car. So it doesn't actually refer to the territory of the nation state there. But it then, in this kind of framing of this case, there's a fairly sharp distinction between inside the firm or outside the firm, right? The firm is a defendant in this litigation. It is being sued, and even though the boundaries got a little bit blurred with GM when it actually settled, perhaps when the firm was not quite in its right mind or whatever, basically here you've got a pretty sharp insider-outsider distinction in the firm. And then the law, that's the courthouse in New York City, the Southern District of New York, where this case was actually held. It reminds me, I forgot to mention before, but one of the judges died during that litigation at an important point. You also had the Supreme Court judges found that too many of them were actually conflicted to be able to actually come to a decision at an important point in the litigation. That's part of the protracted and long-winded nature of the litigation. But the law was very much, from that courthouse, a fairly doctrinal view of the law, right? So pretty much this was a court case, and I mean, there were clearly politics around it, but if we're inside and outside the law, it seemed fairly clear as to what the law was or wasn't. So the way that I went through that history, there were wins and losses, and eventually a loss in this case. I think also but to complicate that inside and outside, I wanted to bring in the perspective of a couple of anthropologists, Sally Engel-Mary and Mark Goodale, who speak about human rights and argue that actually they think about it in terms of, this is a definition, sorry Otto, I know you don't, or Michael Walzer as well. I know you're not into definitions, but they associate the notion of betweenness with human rights. And I've always found this to be actually an interesting way to think about some of the questions of human rights. So I've written it down up here, betweenness as meant to express the ways in which human rights unfold ambiguously, without a clear spatial referent. And I think in part through transnational networks, but also equally important through the projection of moral and legal imagination by social actors whose precise locations within these networks are, at least for them, practically irrelevant. So it's I like that definition, I think, because it's getting to a notion of where it's not completely embedded, but it's speaking about how the individuals or the actors are actually imagining themselves into effectively a kind of universal situation, which I think in many ways is something to be aspired to, but is also an empirical referent that we should be aware of, that that's what's actually happening. Okay, so Kulamani happened. Yeah. Oh, you win. You did. Very good, Lisbeth. So, of course, when your slide earlier today came up, I thought, uh-oh, she's going to take my whole presentation. You took a good part of it, but not all of it. So there we are, one down, thank you. But here is Kiobel, which was, from the perspective of the Kulimani case, right? There, I think at that point, there actually was only one Supreme Court engagement, it's Sosa, Alvarez Michel, engagement by the U.S. Supreme Court with this very ambiguous statute, this, what is it, 2 sentences, right? The Alien Tort Claims Act. So, but this Kulimani case was going forward, and we kept hearing about Kiobel, which was going to be very important, and indeed was. So there it is, going up to the Supreme Court. There's Esther Kiobel. It's about Shell and versus Royal Dutch. It was one of these ATS claims, and as it turned out, it was the second time that the Supreme Court engaged with the Alien Tort Claims Act. So it became the second treatment. The majority enunciates a strong presumption against application outside the U.S. extraterritoriality. I think it's important to notice the concurrence by Breyer and some of the other more liberal judges on the U.S. Supreme Court, because in that concurrence there was some of the rationale there was noting the failure to exhaust local remedies effectively in Nigeria. So effectively agreeing with the notion that, yeah, maybe eventually this could kind of, you could see where a case like this might come to the US, but that it would be important to actually go through local fora. And that's a well-established principle, of course, in public and private international law. But the real impact of Kiobel, as it was, or there was a, I shouldn't say the real impact, but one of the key questions, certainly from the Kulimani point of view, but I think more broadly as well, about Kiobel as it was developing, was this issue about corporate criminal responsibility. Would Kiobel be, and we've heard Elizabeth has really spoken about it quite a bit, but the way that state governments, nation-state governments, but also civil society and NGO communities were mobilizing around that question. So in the paper I talk about from the South African point of view, how there were actually conflicting amicus curiae submissions in from noted South African international law scholars and professors on both sides of those issues. One saying that there should be the possibility of such liability, and the other one saying not. So even the South African community, the sort of expert community, was actually divided as well. So there was lots of mobilization in a technical term there. So Kiobel in the Supreme Court doesn't talk about criminal liability at all, right? There's maybe a sentence that actually sort of goes on this. Now, what do you do with that? Well, you can, which I think Elizabeth did, sort of look at some of the lower court decisions that were actually pretty much foreclosing or being negative towards such liability and speak to that. Some of the South African commentators that were looking at this case afterwards were a little more optimistic. One of our colleagues is David Bilschitz. He said, well, they didn't say anything about it, so they didn't say no, so that's like an implied yes. So that's fairly optimistic reasoning, but that's where he went to on that issue. Okay, so what happens after this case, after the Kiobel? Well, in America, there's some academics who are writing and basically say, what do we do now if we want to continue with that kind of fight and those kinds of claims? And they turn to state law courts, actually. So they're moving down from the federal level to the courts of the U.S., of the various states, where they can put tort law claims forward. and these would be ordinary tort claims. And effectively you could do, it's another platform for doing the same kind of litigation, if you can, of course, get jurisdiction, etc., which we'll talk about a little bit more. They talk about some other statutes as well, kind of more commercial statutes, unfair business practices, consumer fraud, etc. But note that those don't offer any direct relief. So it's really a kind of second best strategy. It's saying, well, we're blocked at going forward with this at the federal level, but let's think about going forward in some other places. And I think some of those cases are going forward. Okay, so America's not the entire part of the world, as I learned when I left there and went to South Africa over 20 years ago. So one of the cases that's in this, in the repertoire of litigations that is going on is one that is cited in some of this literature that's looking at what to do post-Kyoto. And it's the case of the Cambodian sugar, Song Mao versus KT Lyle, which is about a case which I hadn't known of before doing this kind of research, which was about communities of persons in Cambodia when the land was actually effectively taken away from them, and then sugarcane plantations and production companies are going ahead there and eventually taking that sugar and bringing it to the UK. And as part of a strategy of attempting to basically get their land back, they bring this case. And yeah, so that's actually on the third bullet point here. It's this case of Song Mao. It's held up as an example of litigation that would be the sort of litigation that responds to the post-Kyoto international legal opportunity structure, if you want to think about it that way. So the idea is that it's not a full-blown Alien Tort Claims Act kind of case, but rather that it's this sort of very carefully structured, calibrated piece of litigation that actually goes first through domestic structures, then goes through the regional human rights system in Asia, and then only comes to the UK courts. So, and there's an academic, Mahan, who writes on this quite early on and talks about several factors of calibration, that you do this exhaustion of remedies, you make sure you've got jurisdiction, you're actually just doing an ordinary tort, nothing really fancy, you're not doing the kind of human rights framing that we've been talking about here, and you also work on advocacy, non-judicial fora at the same time. I think, going back to the South African perspective, so Rita Kesselring writes this interesting anthropological exploration of the plaintiffs, the actual people in the Kulamani case, case pending, inclusion and exclusion. And this is picked up elsewhere in the literature as well, but making the point that with this kind of litigation going on for 14 years, the kind of delay, the technicality, it really leads to an obscure narrative, and actually to processes of inclusion and exclusion amongst the plaintiffs themselves. So she's an anthropologist, she's not actually caring about whether or not the Kulamani case is winning or not, but actually looking into what does it do to the community of the persons who have actually embarked upon that litigation, or in whose name the litigation has actually been embarked upon. Seppo Madlingozi goes sort of a stage further than that. He's actually writing not necessarily precisely about this case, but more generally about transitional justice entrepreneurs find it interesting actually that he's using the sort of business terminology here of entrepreneurs. But entrepreneurs who aren't producing goods for sale, but actually who are producing victims here. So it's reminiscent of the Macau Wa Mutua, savages, saviors, and victims, line of reasoning and analysis here, but actually pointing to the production of victims in this case. Then some of us will also know some of these writers, Mitali Jain and Bonnie Myersfeld. They're writing and they're asking, actually in large part, one of the questions that I'm really asking, which is, well, what do we do now? Right, from the Kulamani point of view, post-Kyogo. And their answer is, rather than seeking the limited justice of the ATS, why is Africa not looking to embrace and strengthen its own regional power to create robust standards of engagement across the continent and possibly across the global south? And that's why I think it flows into actually the Song Mao litigation as an example, because that litigation was really using the regional human rights system on its way towards eventually going to the UK court. I want to talk more about the public-private distinction as we keep going. So we're now we're getting to effectively now corporate accountability in post-Kulamani, post-Kyogo stage. These photos are showing in the women's jail in Johannesburg on Constitutional Hill a couple of quite significant figures, Nabi Pillay, who as we know is the South African who had been the UN Human Rights Commissioner, Zak Yaqub, who had been on the Constitutional Court. These are some of the events that are actually happening at the moment. So what I think I'm doing here is trying to take a survey of, we had been doing Kulamani, what's happening now? So here's part of the events that are happening. There is non-judicial advocacy campaigns moving ahead. African Coalition for Corporate Accountability started, and it's probably significant, in 2013, right? That it starts when the Kulamani case is apparently, looks like it's not going so well. It's a coalition of organizations that are looking to look at the broad issues of corporate accountability, business and human rights, but supporting communities and individuals whose human rights are adversely affected. So it's a human rights organization strategy based in the Center for Human Rights at University of Pretoria. And a case that looks, or I shouldn't even say it's a case, it's the initiative that looks like the most direct parallel or descendant of the Kulamani case would be an initiative launched against Belgium's Credit Bank at the moment for its complicity and active facilitation in buying weapons for the apartheid regime. Let's see if this goes up as well as down. Yeah. So this is actually the graphic that the NGO uses for that. Whereas this is a historical case then of where money was channeled from Pretoria through various into Belgium in particular as part of violating UN sanctions and buying weapons. So there's, with the COWS and Open Secrets are launching a complaint in front of the OECD National Contact Point in Belgium. And that is not in the style of a court case, in the sense that there are not papers that are launched and then responses that happens back. It's rather a complaint within that framework of accountability. And I want to come back to that in the second movement. A couple of months earlier, there is this People's Tribunal that happens at the public hearings at Constitutional Hill that are investigating, I think it's interesting, investigating arms trade both post-apartheid, or post the transition, as well as during apartheid. So those issues are actually moving together. And they issued preliminary findings that Credit Bank and the French government both have cases to offer. So as I understand the sort of procedural posture in this People's Tribunal, it is that they are effectively kind of, there's a 3-month period now where they're waiting to see if the, quote, defendants will actually be responding at all to this kind of obviously unofficial sort of jurisdiction. Okay, so I think this is the end of the first movement here. We could, and I think we have actually in this room, look at this line of action thus far from this point of view, from a globalized public interest stroke social action legal strategy point of view, right? Social action being the terminology that's sometimes used for public interest, particularly from India, resisting the Americanization of the public interest term. So one could look at the, do a sort of analysis of where to go forward here by looking at the opportunity structure and the power analysis, by looking at multidimensional strategies, institutional targets, to be very adaptable, public interest lawyers, globalized public interest lawyers, not set back by little problems like Kyobo coming along and, you know, knocking you off your intended course or anything, to be collaborative and to be sustainable. And I think Elizabeth was, this is your 4-parts analysis, at least as I copied it down. And I think also that would be an important part of it to have that sort of doctrinal or realistic, you know, what are the questions that we are going to face in some of these litigation. That's not what we're going to do, however. We've already done that. So what we're doing in the second movement, I'm trying to do a transition here. And actually at the same time I need to make an apology because this was the slide that I could find best to make this transition. It does use the term gypsy migrations, and I'm pretty sure that's not something I should be using. So it's got an apology up there already, but I didn't find a better slide. So I can replace it by the time we get there. But I think what I'm trying to do here is to think about a transition from the between a sort of globalized strategy and then some of the questions that we've actually thought about here in this workshop. And it seemed to me that maybe there is some connection between the globalization and then the idea of travelers who are, as we all are, of course, migrants or persons with a migration background. So in the second movement, I wanted to talk about a different type of insideness, and that's really inside the law. And that's this notion of endogenous law, indigeneity, and the work of Lauren Edelman. So we've heard earlier in the workshop that Kim-Lane Scheppel is actually president of the Law and Society at the moment. Well, Lauren Edelman was a previous president at an earlier point. And I think that actually, I was thinking about the themes of the workshop, and it seemed to me that actually it was quite apt to look at her theoretical framework and perhaps to bring it to bear here. So she's got a concept of law's indigeneity, suggesting that actually the economy, through the behavior of firms, adapts to perceived problems. We talked about the garbage can model of problems and solutions, to problems that are outside these firms by producing law-like adjustments inside the firms. And that these adjustments eventually become affirmed by the formal legal system, which is indeed outside the firms. So those inside and outside terms, I think there's 2 outsides and 1 inside, right? Tried to put them in bold so they could be seen. That's very integral to her scheme, actually. That's really a lot of the work that's being done by the theory. So the theme of human rights inside and outside seemed to me to fit into that. One of the important points for this theory, the socio-legal one here, indigeneity, is that language matters. And I think it was Nicola who, not to be here at the moment, but who started out her presentation by saying, language matters, and then went on. And certainly Rachel, who got us to think about transparency as a public discourse, and certainly not as a unambiguously positive discourse. Yeah, it was on that point as well, that the language actually does matter. So language matters, interpretation matters, and very much with this concept or theory, one needs to look at who is interpreting. So Edelman really fits with law's interpretive turn, but is an interesting twist on this by actually asking who is really interpreting the law authoritatively. This is a significantly different paradigm from the persuasion, socialization, internalization paradigm, the way that Edelman goes about it. It's looking at the effect of law in a very different way from the internalization of norms. It's also very different to Foucault and Gramsci, right? Those were the two who were there for Rachel's thing. I think it's consistent, if I'm right, with Annelies, with your findings on the language about the agenda inside the corporation. And again, in the kind of general sense of this, what Edelman's concept is doing is really pushing against law and economic reasoning. Law and economics as public choice, as thinking about economic rationality as a kind of logical given. Much of what Edelman's work is doing is pointing out that actually economic rationality is in fact socially constructed and is in particular contexts. So it isn't the sort of objective objective terminology or concept that actually can be used to necessarily determine kind of right and wrong in a public choice kind of way. So I'm not sure, I want to do a little more to get this model in front of you. How corporations then, Edelman's speaking about how corporations, firms really, are engaging with ambiguous norms, ambiguous laws, and shaping them to their own interests. Pointing out that the compliance is usually more symbolic than actually strategically motivated. So most often, this is a kind of, sorry, it's a gloomy story, right? We ended up that last panel thinking a little bit gloomy, but Edelman's main empirical area is to look at the enforcement of civil rights laws in the US. And she most often is telling a story that's actually about the blunting of social change, where the organizations were able to take these relatively ambiguous laws, interpret them themselves, and thus only symbolically comply, rather than kind of more substantive compliance. I think also this is I thought it was interesting because the INFAR group is talking about asking what happens in side effects, actually, when norms are actually put into practice and then things happen. And those things are not necessarily always motivated. So it's really looking at law as a social process on the functional side, and I think that's where Edelman's theory is pointing us to. So here's a visualization of the model. This is her kind of 2016 book about courts, corporations, and symbolic civil rights. But here you've got a story about an ambiguous issue. Yeah, look at that. Okay. So an ambiguous issue here. This is actually from a slide that's talking about sexual orientation protective policies. But we this issue to where the organizations, through their managers, are actually developing these policies. They are then amongst themselves thinking, okay, we are complying. They implement those policies. And then here's the kind of part to it, trick part to it. After those policies are implemented, the legal consciousness that this is actually what those norms meant, or that the implementation of these policies is in fact the law, begins to develop, both within those firms, but also within what the sociologist organization called the organizational fields. There's kind of, this theory is more complicated as both legal fields and organizational fields, but effectively it's within the organizational field there is an actual legal consciousness that develops there. It gains legitimation. Those policies are then mobilized, and then the courts think that they are coming up with the law, but in fact they are deferring to the practice that is actually developed within the organizations themselves. So the judges actually end up ratifying the understandings and the constructions that are developed within the firms and within the organizational field. And then that just keeps going. So that theory can actually be globalized. I mentioned she was the president of Law and Society Association. She gave a speech, and it was globalized, and I think I'm going to actually have to speed up in order to make sure that we hit our 5 p.m. time, so I'll do that. And I think that means that I think there is a parallel here with rule of law theories, but I'm trying to look at the sociology of law take on it here. So what do we then, can we use this theory in a way that actually makes some linkages to the topics that we've spoken about so far today and yesterday? So as I've mentioned, a lot of her work is about the symbolic-only compliance. I think she makes the point that the potential for law to become endogenous originates in the ambiguity of the legal rules. So Helen Hinchtens was speaking about the sudden change in, I see smiles, I think I didn't do a good pronunciation there, of the sudden change in the interpretation of Article 14 around Roma, the anti-discrimination regarding to Roma communities, and I think that's actually, she was making the point that there's the potential in the law for ambiguity. She was also speaking to the historical structures for the understanding of that particular law. Another is that this kind of theory is alive to the potential for the contest of the meaning of compliance, that this is actually particularly likely where there are multiple stakeholders. So we had discussion more yesterday about Prince Charmings, right? That there were actually a lot of them, right? It seemed that they were stakeholders that in the case of, again, the Roma community, but they might have different ideas. I think this also came up in the SAS France case. And also in the notion that, and this is part of the linkage in this particular topic, when we're talking about citizenship and discrimination, that's the kind of direct parallel from the civil rights law that Edelman was looking at, that it could be that merely because there are grievance or complaint structures that are actually set up, that is taken as evidence of fair or non-discriminatory treatment by the courts, whereas that is not actually in substance compliance with that anti-discrimination law. So I thought there were some linkages in that topic. Then this slide moves us into contested constitution. Sanele puts up his hand and gets the second tick for certain because these three slides speak to the three instances. You didn't actually answer that question, did you, Samara? You left it for us to, what was it? It was, what was the answer? Well, wait a minute, let's go back to the question. Right, there was the judge who was accused of speaking to two other judges and saying, it's in your hands, what are you going to do? There were the service delivery protests, 10,000, what was the number you quoted? Something like that. Yeah, and then there is the EFF in Parliament, the red uniforms with the white guys being the security guards that are actually throwing them out of the South African Parliament. And Jackie, you're saying the answer is? Okay. So, I think in this contested constitutionalism topic, one of the linkages I thought from the laws indigeneity approach was to point to, and we won't have time to explore it more here, but the emerging political economy approach that's very much inside the South African constitutional tradition. I think that's got to be distinguished from political economy critiques of constitutionalism that are outside constitutionalism, which itself can be critiqued when, for instance, David Schneiderman talks about the rigidity of international investment rules as becoming too much constitutionalized and thereby reducing the policy space of nation states to fulfill their democratic mandates. So that's going through things very quickly. But the development of a political economy approach within constitutionalism in South Africa, we've got Samela Sibanda, and this is a quote from you yesterday, constitutions speak to the economic and not just the political. We've got a critique of actually the framing of social justice by Tsepo Madlingozi, to some extent at least drawing upon an economic framing for that critique. I think also with Jeff and Will, I had some questions there. It's mostly on the public side, but I was interested to know where the place of business was in the development of the contested constitutionalism you saw in Suriname, and also maybe beginning to ask in endogeneity, where do those presidentialist notions evolve? And since the civil service was so large there, I thought that might be a place to look. So this is our second to last slide. This is another current piece of litigation or happening in South Africa. It's the silicosis class action. It comes from post-Kyoble. We've got a number of claims brought in English courts, but we actually have a number of claims that are actually going elsewhere as well, because this is our DJP, Phineas Marchipello, who makes a judgment that actually has an effective class action in South Africa for the victims of silicosis, well, for persons who are suffering from silicosis after being working in the mines. It's got an interesting feature in the case where basically the mines legal teams were lily white. I think that's pretty fair to say. So black advocates staged a protest in the court to say actually what is going on. And there was real action that happened from that, at least in the sense that the Johannesburg Bar adopted a rule that at least one out of every 3 persons on a team would need to be a black person in a similar kind of case. So this is our very last slide. That that class action, I think, needs to be looked at in historical perspective. There was the asbestos litigation that actually led up to that. But it was interesting that immediately post-Kyobo, that this actual litigation in 2013 and 2014 was pointed to as we're losing in the UK courts. So the silicosis settlement was being pushed away from the UK courts. And it was seen at that point as part of, well, what do we do afterwards? And I think that now it's actually become maybe celebrated as too strong, as nonetheless as a success. It's certainly a successful legal action in South Africa, but it's as yet unanalyzed and unproven. I think that, I guess what I'm pointing to then is the need for, certainly in this area of business and human rights, to move away from, what I meant to say here, I've spoken to you about that, is I found in your talk an example of the ambiguity of the meaning of a law, the FPIC, the full prior informed consent, that actually there could be different models there, that in fact the corporations could effectively push in one way or the other according to their interest at the time. So this is a suggestion of moving away from a compliance, non-compliance model and more towards looking at the way in which inside the law, inside corporations, business is actually constructing the law and compliance. And we can look at that particularly in the mining industry. And that is it. That's a picture of a meeting as part of research.
So we, of course, reached the end of our conference, and this is still okay. And of course, there's always lots of people to thank. Above all, more than anybody else, you who have stuck it out for the last day and a half, have had these discussions with us over a very long period of time, and really, especially people like Harris, who I hope is still here. There he is. Yes. And who else? Well, Erica, indeed, from the ISS, and I think another student assistant who was involved. Michelle, yes. We always rely, of course, not only on each other, but on our intrepid student assistants, our interns, and we very much appreciate your contributions to this project. Please, we have a little something for you. Give him applause, please. Thank you. Can you please give this to your colleague also? Yeah, and I will ensure that Erica gets this. Michelle, thank you. Yes?
And I want to extend a particular thanks to Jonathan. Jonathan, you were kind enough to we pre-invited you to just speak on the conference in some panel, and then we asked you, well, could you please do the keynote? And you were willing to reshape your talk and connect your talk to all these different themes. So very warm thanks to you. And I have a small thing to give you as...
Thank you. That's so nice.
Thanks a lot. Okay, well, I think this brings us, unfortunately, to the end of these 1.5 days. I enjoyed it. I mean, which is as an organizer, you're never always completely sure that you're going to. So, but I did, and I think Jeff was smiling and and frowning and very engaged. So that was good. Nathaniel and Kinnery, I hope you enjoyed it too, and thanks for your contribution. And well, yeah, to more meetings, gatherings of all sorts, I would say. I would say thanks again for being here, and enjoy the weekend.